In this video, I'm going to cover a question I often get from clients, which is, will you go to jail for driving on a suspended license? The answer is, it depends. Here are 3 things you need to know about whether you will go to jail for driving on a suspended license. First, can you go to jail for driving on a suspended license? The answer is yes. Under Section 53, subsection 1 of the Highway Traffic Act of Ontario, you could go to jail for up to 6 months on a conviction for driving on a suspended license. 2, going to jail depends on these factors. So, whether you go to jail or not depends on multiple factors. One of the key factors is the number of prior convictions that you have for driving on a suspended license. Generally, jail is considered on a 3rd conviction of driving with a suspended license within 5 years. However, jail is possible even on a 1st or 2nd conviction if there are aggravating circumstances. For example, there was an accident that caused significant property damage, or an accident that caused bodily harm or death of another person. In those cases, you may go to jail even if this conviction is your 1st or 2nd conviction. 3rd, this person will decide whether you go to jail or not. This person is the justice of the peace. He or she will be the final decision maker on whether you go to jail for driving on a suspended license. However, a key person in the decision-making process is the prosecutor. In your driving while under suspension court case, the prosecutor will make a recommendation to the justice of the peace regarding penalty, and generally the justice of the peace will go along with the prosecutor's suggestion as long as that suggestion follows the guidelines set out by the Attorney General of Ontario, and those guidelines do include potential jail time. As a next step, watch our video, Is Driving Under Suspension a Criminal Offense? You can click on the video on your screen. And if you have any questions, message me to arrange a confidential meeting.